Welcome back, or welcome if you've just joined us. If you've just joined us, then I apologise to the about 200 people who've heard me say this 3 times already. I'm Maeve Cook. I'm the chair of the Royal Irish Academy Ethical, Legal, I always get this wrong, Ethical, Political, Legal and Philosophical Committee, Studies Committee. I'm overall chair for this afternoon, and I'm about to hand you over to the chair for our 4th and final panel discussion. The topic under discussion is, the question is, how should a liberal democracy react to, it's about reacting to conscience claims in the public square, and the context, of course, is the liberal democratic public square. I'm going to hand over now to chair, who's Bryan Dobson. Bryan Dobson has worked with in RTE and for RTE News and Current Affairs for more than 30 years. He is currently presenter of the RTE Radio News at 1. Prior to that, he was a presenter of RTE's Morning Ireland show, and for many years he was one of the anchor people at the RTE 6-1 television news. So Bryan, over to you, and thank you to all the panelists for agreeing to be part of this very important and topical discussion.
Well, thanks very much indeed, Maeve, and welcome to this, our final session this afternoon, our discussion reacting to conscience claims in the public square. It's been a fascinating afternoon. I've been intrigued to listen to the speakers and the discussion, and to hear the questions that have come from the virtual floor over the last couple of hours. And we encourage you to do likewise during the course of this discussion in the next 40 minutes or so. We've been listening to debate and discussion in relation to conscience in the ethical domain, in the legal context, and in the religious context. And we, I suppose, bring it together now with reflections from our speakers. That's what we've asked them to do, on their own thoughts, but also on what they've heard over the last couple of hours. And if you like, I suppose, to begin to try to give practical application to some of the issues that we've been talking about in terms of how legislatures, how governments, how the public space, if you like, responds to some of these issues. If you like, in the broader sense, the politics of conscience. And to do that, I'm delighted to welcome our 3 speakers this afternoon. Let me introduce them to you in turn. We have, first of all, from the Queen Mary University of London, Dr. John Adentire, who is a lecturer and author of the General Right to Conscience Exemptions, and editor of Religious Beliefs and Conscientious Exemptions in a Liberal State. He received his doctorate from Fitzwilliam College, University of Cambridge. John, you're very welcome this afternoon. Thank you for taking time to be with us. We're also joined by Professor Fiona de Londras, Professor of Global Legal Studies at the University of Birmingham and an honorary professor at the Australian National University. Fiona is an alumni of University College Cork. Her work focuses on human rights, transnationalism and constitutionalism, including reproductive rights, which we've already been talking about in some of the discussions this afternoon, and no doubt we'll return to. And finally, we have Senator Michael McDowell, who is a member of Shannon Éireann, the upper house of the Irish Houses of Parliament, an independent senator of Shannon Éireann. He's a practicing senior counsel and a former Minister for Justice, Equality and Law Reform, and a former Attorney General of Ireland. And on your behalf, I'd like to welcome them and thank them for taking part in our discussion. The format is the same as we've become familiar with during the course of the afternoon. I'm going to invite each speaker to address you for about 10 minutes, and then we'll take questions from you, the audience, for the concluding part of the session. So it gives me great pleasure to ask, as our first speaker this afternoon, to invite to the virtual podium, if I can describe it as that, Dr. John Adentire. John.
Thank you very much, Bryan. And it's great to be in such company, and I've really benefited from the discussion that have preceded this panel. And I will try in these 10 minutes I have to tie in some of my presentation with what has already been said. So I want to address the 2 main questions of today. So how should a liberal democracy assess conscientious objection claims? And second, the more specific to this panel, how should conscientious objection claims be understood in the public square? How should politics react to it? So in relation to the first, my work has been to defend what I call a general right to conscientious exemption. And by this I mean a legal right which is available to all those that conscientiously object to any legal obligation whatsoever, whether on the grounds of religious belief or non-religious belief. So how does this relate to some of what we have heard today? Well, we have heard a lot about particular conscientious objection, objections to military service, objection to perhaps being vaccinated for COVID, objection in the medical context. So I view these as particular instances of conscientious objection. Yes. So my work has been to document a broader right, a right that can arise in any context whatsoever, as long as there's a sincere conflict, as long as there's a conflict between a sincere conscientious belief and any legal obligation. So this can take place in the context of private enterprises, so employment relations. But of course, it can also take place in relation to general legal obligations, such as a mandatory vaccination mandate. So a lot of my work, and especially in my last book, A General Right to Conscientious Exemption, which was published very recently by Cambridge University Press. In this book, I make a moral and legal defense for this right. So the moral defense ties into the second question for today. So how should how should conscientious exemption claims be understood in a liberal democracy, especially in the public square? Well, my defense of this right ties into some of the discussion that we have had at the beginning of in the first panel, the moral justification for conscientious objection generally. So of course, ideas of respect for individual integrity, respect for private conscience, respect for pluralism of beliefs. These are all valid reasons to have a right to conscientious exemption. But these are not specific enough to a general right. Remember that the general right is a right to object to any legal obligation whatsoever. Right. And so the moral case for this right is made on the grounds that we live in a pluralistic society, a society where people have different and conflicting moral views about what they ought to do vis-a-vis legal obligations. And different groups having this, different individuals having these moral views have different levels of access to power, especially political power. So there seems to me to be a democratic or quasi-republican case for making a general right available to all, because not all have access to the political forum. So there should be an alternative forum, in this case a judicial one, where these moral minority views can be heard. So this is the justification for a general right. It is one that is grounded on political participation, really, political participation of moral minority views. Well, so far I've been talking about the general right, and I've said that it should be available to non-religious and religious objectors. And in the previous panels, it seems to me that there's a consensus, even within the theological panel, that the right to conscientious objection should be available to those that are religious and non-religious. So I will not spend time on this issue because it seems that there is a consensus, at least in this place. What I will spend time on in the last 4 or 5 minutes that I have left is on this issue of the limitation of a general right. So I only, of course, talked about the moral case for the general right. In the book, I also, most of the book actually is concerned with the legal grounds of the general right. And I show in the case of the US, Canada, and UK, that existing constitutional and statutory principles, usually related to freedom of conscience and religion, or prohibition of discrimination on the grounds of religion or philosophical belief, legally ground this right. But in all of these cases, given the legal grounds of these cases, given the legal grounds of this general right, the right is not an absolute right. Standard liberal rights, as has been discussed, especially in panel 2, tend to be limited rights. That is, when someone goes in front of the court and makes a claim to be exempted from this obligation or that obligation, judges have to decide why and why they should be exempted, if at all. And the usual grounds related to our liberal tradition is that an exemption may harm third parties or may harm important and vital public interest. So a good part of my work has been directed to adjudicate the conflict between the general right to conscientious exemption and particular instances of conflict with other important rights, and given our circumstances and some important cases, the rights not to be discriminated against. So chapter 9 of my book focuses on the right of LGBT people not to suffer discrimination by those that invoke a right to exemption from anti-discrimination law. So as I think, especially in the second panel, there was a discussion on the gay cases in the US and the UK, but this kind of what Ron and McCrea has called complicity cases have arisen everywhere, in Canada, in Poland, and many other places, and of course in Ireland too. And there, the argument, and this is how I will finish. How should we balance the rights to conscientious exemption against the right not to suffer discrimination on the grounds of sexual orientation or gender identity? Well, we have to make recourse to standard liberal values, right, and to the idea of dignity. I make recourse to this idea of dignity, that when a claim to exemption would entail imposing dignitary harms onto others, shaming them, but also and especially when such exemptions would entail treating people as second class or third class citizens, then these exemptions should not apply. So usually in the cases of the gay cases and similar, but not all, the general right should not win out, should not be granted. The right to exemption should not be granted. And this can, of course, be extended to objections to COVID vaccination if they are ever made mandatory. Okay, so I think I've run out of my time. I welcome further questions in due course. Thank you very much.
Thank you, John, for that. And we will come back to some of those themes and issues which you've touched on there, I'm sure, a little bit later. But let me now hand the floor to Fiona. Fiona.
Thank you very much, Brian, and thank you to everyone involved in organising this wonderful event. It's a pity that we can't all be together in Dublin, but hopefully that will happen soon. So picking up on the injunction we received to think about how a liberal democracy should react to conscience claims, particularly in the public square, I want to pick up on some of the themes that have come through the panels today and to concretize them by focusing in particular on the invocation of conscience in the context of the provision of abortion care. And I want to do it around 4 propositions that I hope in themselves are not massively controversial. The first proposition is that I take a liberal democracy to be a rule of law based democratic state in which individual rights are recognized and protected. And one key implication of this for me is that when we think about how we react to conscientious objection claims, we must think not only about the holder of the conscientious objection as a rights bearer with whom we ought to be concerned, but also the multiple other rights bearers who are affected by the invocation of conscience by that person. John has already really set the stage for me on this by talking about harm, dignitary harm and otherwise. And so for me, one of the key implications of that first observation is that if we are in a liberal democracy to accommodate conscience claims, which I don't think we ought not to do at all, then that means we must arrange the provision of public goods in particular in a way that maximizes the rights of all. And that may mean some limitation or regulation of the invocation of conscience. So that takes me then to my second point, which is around, I think, the importance of being precise in our understanding of the kind of a claim a conscientious objection is. And here I'll be a lawyer about it and say, let's just look at how that is constructed as a matter of law when we look at the rights to freedom of conscience, religion or belief as protected across international human rights law and in domestic systems. The general structure of that right, which relates to what others have already said today, is that while there is an unlimited right, an absolute right to hold a thought, conscience, or belief, the right to manifest that thought, conscience, or belief is not absolute. In other words, it can be subject to limitations limitations that are necessary in order to protect public goods. Sometimes the permitted limitations are specified in a particular piece of law. For example, the International Covenant on Civil and Political Rights would specify that you can limit conscience manifestation for the protection of health. And so in the context that I'm particularly interested in, that is the provision of abortion care, that's clearly a limitation that would arise. And so we need to distinguish between the holding of a belief, religious or otherwise, and the capacity to exercise that belief or to manifest it. And where state regulation has a legitimate role is in respect of that latter matter, the regulation or limitation where necessary of conscience or belief in its manifestation and not in its holding. And so that means taking me to my third point, and again echoing something that John has already said, that in order to identify whether and if so to what extent the manifestation of conscience by way of what is known as a conscientious objection should be accommodated or limited in the law, we have to understand the harms that that manifestation might cause. And I think picking up on something Linda Hogan was saying, it's really important that we understand that our, by which I mean the state, conceptualization of harm that requires state intervention is very much contextual and socially and historically constructed. And so if we talk about conscientious objection to the provision of any part of abortion care, information, referral, abortion itself, post-abortion care, and so on, it's important that when we try to understand what harm that might cause, we recognize that our understanding of harms that require state intervention is itself a product of a system, a patriarchal system, in which there was no conceptualization of pregnancy as being possible of being a harm, of motherhood as being possible of being a harm, because pregnancy and motherhood were core to the conventional gender construction of women. And so if we are to understand how we react to or ought to react to claims of conscientious objection in the public sphere, then I think we have to understand, be conscious of, and be critical when we think about what we identify as an appropriate harm. And when we come to abortion, for example, there is a wealth of research, qualitative, quantitative, from all over the world on conscientious objection and the harms that it causes. And it's interesting to note that the harms that it can cause are actually across numerous different stakeholders. So there are harms to the person who's seeking an abortion. The harms may be greater or lesser, depending on the context in which her desired abortion is refused. So if you live in a very rural area or you have very limited provision of abortion care, then a refusal may have a different harm, a different degree of harm to the degree of harm you would experience if you lived, for example, in a metropolitan area where there were multiple potential providers. You also have to think about the ways in which conscientious objection are exercised. There is well-documented cases, although rare, of conscientious objection being punitively exercised. So people being punished during conscientious objection, being verbally abused, being purposefully referred to services that do not provide abortion when they're seeking abortion, being given misinformation, and so on. So you have lots of dignitary and health harms that arise in those kinds of cases. And we could go on more about that later. There are also potential systematic harms, harms to the healthcare system, because conscientious objection can result in the diversion of work and resources, also the diversion of patients. And for me, the way that the public sphere reacts to a claim of conscientious objection in abortion doesn't really depend on the sincerity of the conscience claim, because this is, a regulatory quandary that has to be dealt with. But at the same time, it is important that we note that it is well established that conscience is invoked not only for sincere reasons of conscience in the context of abortion care, but also sometimes in order to minimize workload, where abortion provision is highly bureaucratized. There's a lot of paperwork, maybe there's a lot of criminalization involved in it, and so on. Sometimes people claim a conscientious objection in order to opt out of an overly burdensome system of healthcare provision. And in some settings, people claim conscientious objection in the public sphere, but provide abortion in the private sphere. In other words, conscientious objection acts as a rent-seeking device or a corruption device within the healthcare system. And so you have multiple harms actually that will arise in terms of conscientious objection in the context of abortion. But that doesn't mean that we ought not to accommodate it. And this takes me to my fourth and final point. And that is that in determining and I suppose reacting to what I would call the regulatory conundrum that conscientious objection raises for legislators and policymakers, we must recognize the harms that are caused by recognizing the authoritative experiences in people's lives of seeking to access abortion in objecting contexts, but also then try to develop a regulatory response that itself recognizes the constraints and nature of the system. So if you have a healthcare system where there is a very low number of general practitioners, for example, then you might need to think, and you would have a high level of conscientious objection, then you should think about pluralizing who may provide abortion care, for example, nurses or auxiliary nurses or community care, especially early in pregnancy. Or if you have a system where healthcare is primarily at the complex end, delivered in hospitals that are under religious ethos, you should think about how you accommodate or deal with that in how you accommodate conscientious objection. And so for me, what the state should do in response to a conscientious objection claim in the context of the regulation of abortion is to recognize the reality of the system it's working in. If it values conscientious objection, then ensure that as it values that, it does not devalue the autonomy, the right to health, and the reproductive agency of women who may seek abortion care, and thus arranges its laws, its policies, its resources, its distribution of doctors and nurses, its hiring practices, its professional regulation, so on, of the medical and healthcare sectors in order to try to strike that accommodation. And that really will never happen if we do not pluralize the focus from a sole focus on the conscientious objector to a plural focus on that person in their connection with all other people in respect of whom their objection may cause harm. Thank you.
Thank you very much indeed, Fiona, for that. Again, some stimulating thoughts, which already are prompting some questions from the audience, which we'll no doubt be coming to in just a moment. After we've had an opportunity to hear from our final speaker this afternoon, Senator Michael McDowell. Michael.
Bryan, thanks very much, and congratulations to the RIA for organising this very, very interesting day's activities. Can I just set up my stall slightly for a second? I would consider myself a liberal Republican. My general attitude is kind of legal positivism. I don't really, I'm skeptical of general theories and abstraction of concepts divorced from actual concrete circumstances, as Fiona just mentioned there in relation to the abortion matter. And my feeling is this, that first of all, when we use the word liberal, we should be very, very careful not to confuse it with libertarianism. You know, that moral libertarianism is a situation where everybody can do and believe and whatever they want as they wish. But a liberal society is more constrained than that. And as somebody said on one occasion, happiness is a state of mind, it's not a destination. Well, I believe that of liberal democracies, that their liberal aspect is more a state of mind than a preordained outcome in terms of a set of rights which can be viewed across time as a model towards which we're approaching. So my view is that we have to, when we come across a concept like conscientious objection, we have to look at it from every side. I mean, for instance, Fiona's elaborated there the whole question of conscientious objection as it affects women's right to choose, and whether pregnancy can be seen as a harm and the like. But a lot of issues come to be considered under the general scope of conscientious objection. I mean, clearly pacifists and conscription is one. Clearly, say in religious fundamentalists such as Hasidic Jews and the like, they have ways of life and belief sets which set them apart to some extent from the constraints of ordinary citizenship. I'll give you an example. There are some people in America who actually believe that they have a conscientious objection right to opt out of paying taxes because their taxes may be used either for military purposes or for contraceptive purposes or for abortion purposes, or you name it. So when we come to applying the notion of a conscientious objection, I think we have to be clear that it is a hugely broad concept, and if we overly try to make it abstract and definable and a set of principles which apply in every circumstance, A, I think that's a rather redundant activity, and B, I think it could end us up in cul-de-sacs, democratic and moral cul-de-sacs. I'll give you an example. The French Republic places a huge value on laïcité, and that allows recent French political figures to actually seek to ban face coverings in public and burkinis on beaches. And now, of course, the laugh is that we have, in the course of a pandemic, we have all sorts of societies in Europe saying you must cover your face, but for a different reason. And one would say, oh, well, we have to protect society from a pandemic. And the other was somehow slightly different. It was saying that overindulgence of individual religious beliefs was somehow subversive of the republican and secular nature of the state. We have in Ireland a long tradition of people claiming the right to opt out of things on conscientious objection grounds. Chemists who 20 years ago claimed that they had to be exempt from the obligation, as they saw it, to sell contraception. But to give you a more recent example, I mean, there was the gay cake case in Northern Ireland, which eventually was decided in a way which nobody had seen at the beginning, that it wasn't discriminatory against the two people who ordered the cake because they would have refused the cake to anybody gay or straight. But on the other hand, you have to ask yourself, you know, could a liberal baker in Dublin refuse to do a KKK cake, to bake a KKK cake or a Make America Great Again cake or whatever? And we also have to take a look at issues such as halal, kosher methods and the implications for what we could or could not be cruelty to animals, depending on how you see it, on the one hand, and much more human things such as a clear, huge consensus against FGM and a question mark over parental rights to impose male circumcision on male children. And that brings me to a second point, and that is that individual autonomy is one characteristic of a liberal society. But an extension of that is the individual qua member of a family and the relationship particularly of parents and children to their children, parents, next of kin, and the right of the state to supplement or to substitute itself as guardian of children through social workers or whatever. And there are issues now which are coming down the tracks at us, such as gender choice decisions and gender suppressant chemistry and the like, and the right of parents to somehow make their decisions for their children, or not, as the case may be. One case that I was a very strong supporter of the Repeal the Eighth Amendment movement. I'm a strong supporter of gay rights. I was a strong and vocal advocate of the marriage equality referendum in Ireland. But I'll give you one example of what I consider to be slightly troublesome. There's an Australian rugby player called Israel Folau, who's an evangelical or a religious fundamentalist by personal persuasion. And he had views about the morality or immorality and what the hereafter held for gays, and he expressed them. And he was run out of rugby for refusing to recant his position. Now, for a liberal, that's a slightly troubling situation, especially when we consider that 150 years ago, if he'd expressed the opposite view, if he'd had said, this is all fine and there's nothing immoral about gay sex and all the rest of it, he probably would have been run out of, well, it wasn't professional rugby at the time, but polite society in a whole series of ways. So to sum up, my position is is as follows. I don't believe, by the way, maybe I should just say one last thing. We have the rights of parents in relation to PKU tests. To the Supreme Court in Ireland said that they are entitled to say no to a compulsory blood test on their children to screen against disorders. We have the rights of parents, on the other hand, Jehovah's Witnesses, as Gerard Hogan mentioned earlier, to withhold blood transfusions from their children. We have a whole series of different and diverse circumstances. And my tuppence worth this afternoon is to say that I think it's that a general right of conscientious objection is more or less meaningless, and that a complex liberal society should concentrate instead on individual cases, applications of values to individual issues, whether it's Israel Folau, whether it's PKU tests, whether it's circumcision, whether it's euthanasia or abortion or whatever, that these are circumstances in which you cannot extrapolate completely from first principles. And to go back to the point that John mentioned earlier, and that is the avoidance of harm. And then Fiona sort of extends that to, you know, pregnancy can be a harm. And there is a question, I mean, I'm not a mad adherent of this at all, but there are people who sort of say it's astonishing that nobody talks about the harm to the unborn. All I'm saying is elaborating a kind of a theory of conscientious objection that will fit all cases and all issues is very difficult, and I think of limited value. I think we're better dealing with things much like the common law does on a case-by-case basis. Thanks very much, Bryan.
Thank you, Michael. Thank you for that. And a good few questions coming in, which I'll come to in a moment. But I think because you've been very clear about your view on this notion of a general right to conscience exemption, and that's at the heart of what John was talking about just a couple of minutes ago. Can I go back to you, John, on that and to respond to what we've heard from Michael in relation to, he says, dealing with these issues on a case-by-case basis and not over-try, I think was the word Michael used a little earlier, to devise general principles here. What do you say to that?
Thank you very much, and thank you for giving me the opportunity to respond on that point. I think the objection is persuasive to the extent that we cannot consider issues of conscience in the abstract, right? The resolution of the cases has to be always contextual, and there will be different solutions depending on the resources we have, depending on the moral harms or legal availability. So I definitely take that critique as well. However, I would still insist that we need a general right to conscientious exemption, on the basis that, as I said earlier, not everyone has the same political power to make their cases heard. So if we all agree that we should consider case by case, we should consider issues of conscience on a case by case basis, then we need at least a access to a forum where our case can be considered on its particular merit. But it is the case that not everyone has access equally, both as just a pure matter of political fact, to influence legislatures to hear their cases, right? They do not have the power to lobby legislatures or the relevant policymaker to hear their cases. So that's why I think there's value in having a general right. But as I said, the general right, the resolution of particular cases will then turn on the merits.
Fiona, do you have a quick comment on this?
On the general,
yes.
The question of general, well, I think, look, there is a value to having general principles, but you can't really figure out how they would work or understand precisely how they would mitigate harms unless you apply them in concrete cases. So developing sort of, and I think John would agree with that. I think he's talking about a general principle that then gets applied in particular ways. And there is a value to having a general principle in terms of how we would approach questions of conscience as a regulatory matter whenever they happen to arise. And we have it, in many ways we have it, it's a proportionality principle in law. You know, we ask, what is the limitation to this person's conscience? What is the good that we seek to achieve by limiting it in this way? And is that good justifiable? Is the limitation justifiable? So there is a mode of reasoning. I think for me, what I take from John is that he would take rather a broader view of the basis or sincerity or whatever of a conscience claim than might many people.
All right. Well, now let's just come to that. You mentioned sincerity just now, and in the course of your comments a little earlier, you said that conscience claims or addressing conscience claims does not depend on the sincerity of the conscience claim, and that's prompted. And also, John, you referred to this question of sincerity, prompted a couple of questions. Alison McWhinney asks, this is addressed to you, John, but we'll put it to the panel. Surely, the sincerity of a claim cannot be a valid consideration. One can have a sincerely held claim of conscience that is deeply morally repugnant. And there's one other person, Tanya Pagotto, I hope I've pronounced your name correctly, Tanya, asks, are we always taking for granted that objections are sincere, that objectors are sincere in exercising their conscientious objection claims? Is there any way to assess the objector's sincerity without being intrusive or illiberal? John, let me bring you on that, and I'll come to Alison and Michael in a moment.
Just reading some of the questions on sincerity, I do not think that insincere conscience claims should be granted. Right. So if you're making, let's take a classic example. Quakers used to be exempted from participating in the war, but some of them just were not. Did not have a sincere objection to military intervention, maybe because they were only Quakers in name, so to speak, and did not adhere to the principle of pacifism necessarily, right? So insincere conscience claims should not be granted mainly because they are not conscience claims, right? The conscience is about a belief, a sincere belief that you would be engaged in moral wrongdoing if you comply with the law. But if you do not actually have that belief, then your case cannot even get started. But sincerity is only one ground, as Fiona has already said. Judges usually employ a proportionality analysis to resolve this case by case.
Yeah, but Fiona, Tanya's question is there any way to assess an objector's sincerity without being intrusive or illiberal?
So I'll speak in the context of the provision of abortion, which is the context that I would know best. And I would say that there is both no, reasonable way to do it, and also that if you were to start testing the sincerity of someone's conscience belief, you would divert resources away from addressing scenarios of insincere conscientious objection, if we call it conscientious objection for shorthand in those cases. So to elaborate briefly on both of those, first of all, we could have a system where, and some countries have this, where you have to declare whether you're a conscientious objector or not when you enter into publicly funded healthcare provision. And there's no test there around sincerity, which is just the system. But in fact, a system like that, which is a kind of a pre-declaration system, has a lot of perverse effects within the healthcare system itself. Because the reality is most people are neither absolute objectors nor absolute providers. Most people's conscience places them somewhere on a spectrum where they make a judgment in individual cases about their comfort level as a matter of conscience with the case that is before them. If you have sincerity tests, which I don't even know how you do it, or you have pre-declaration, you actually take people on a spectrum out of the healthcare system, you disincentivize conscientious provision by forcing people to be on one or another end of a spectrum when most people reside realistically somewhere in between. And that's one of the benefits of organising your system of healthcare in order to accommodate conscientious objection. You give people a little bit of freedom. But the second thing is, if we focused our energies on trying to test whether or not people were making sincere claims, we would in fact not be using our resources to understand why they might be making insincere claims. In other words, within an abortion provision system, what are the structural issues that compel people to opt out if it is not their conscience? And usually it's over bureaucracy, insufficiency of providers, so burnout. They're exhausted because there are too few people who provide. The possibility of criminalization, sting operations, and so on. So we'd be better to spend our energies on trying to address structural matters so that people with conscientious objections could exercise them. And there's a few questions that ask about that. In case I wasn't clear, I don't think they shouldn't.
Yeah, and maybe I can bring Michael in on this because, as a lawyer, as a legislator, as a former government minister, Gavin is asking, could Fiona and the panelists address the harm caused to conscientious objectors by denying them legal protection? Much has been said of the harm caused to third parties, but how can society respond to the harm caused to objectors themselves, and what protects them?
Well, I mean, there's a few points here. Just in relation to sincerity, can I just put in by way of footnote to what John and Fiona have said, that it may well be that sincerity should be a necessary but not a sufficient condition if you follow the distinction. In other words, that you may make provision for people who have, say, a religious view about halal, to slaughter animals in a particular way, or people to wear particular face coverings or whatever. But it doesn't mean that because you accord it to one citizen, you must accord it to all, regardless of whether they have this sincere belief behind it in the first place, if I may say so. So that's the issue there. Going back to the question of harm, I mean, for instance, to take Fiona's case about pregnancy being a harm. Being compelled to proceed with a pregnancy in certain circumstances is manifestly harmful. I mean, a rape victim who could take a morning after pill and is denied that and is forced to go through a 9-month gestation period, I would say, is a harm to that person. To me, that's self-evident that is a harm. But there are other areas where, you could, the old red lights begin to flash, like saying to a 12-year-old, you can choose your gender and you can go on puberty blockers independently of your parents' advice or whatever, or doctors can allow you to do this even though you are incapable of having sufficient moral capacity to buy a lotto ticket at your age. There are issues here where what is seen as harm or prevention of harm to the individual themselves is one where society does sort of intervene as a moral protector, not merely of individuals against the actions of others, but individuals against damaging themselves in certain circumstances.
Fiona, Bernadette Kiley has an interesting question, which I think maybe is prompted by your own comments. Would you agree, she asked, with those who say that in the case of a morally contentious treatment, now she cites a number of things, abortion, euthanasia, FGM, or whatever, is it the duty, this is the heart of the question, is it the duty of the state who legalizes the contentious procedure to provide a pathway for people to access it, rather than requiring the person who objects to the treatment being involved in that pathway? What's your reflection on that?
I would say that encapsulates very well the position in international human rights law, which is to say that a state may allow conscientious objection, as for example Ireland does, but when it does so, it must organise its system in order to ensure that objection does not constitute a barrier or denial of abortion care. Like that, so that's the standard. And that is certainly the argument that I would have been, the core of the argument I would have been making around arranging legal regulatory matters, arranging the system. If we're going to allow objection to the provision of abortion care or other forms of healthcare that for some people are morally contentious, then we may only do that if we ensure that in doing it, we do not also harm the person who seeks to access the care. And that means ensuring adequate modes of provision and access that are equitably distributed and that are not disproportionately unavailable to persons who cannot afford, for example, to access it privately.
All right. And John, perhaps one for you. And again, forgive me if my pronunciation is a little lacking here, but Yuri Shilazhenko asks, should liberal democracies support conscientious objectors oppressed under illiberal regimes abroad, for example, objectors to conscription in an authoritarian country waging an aggressive war or denying human rights to freedom of conscience?
So I have no special expertise in this particular area, so I'll just say my personal opinion. I think in general, if there is wrongdoing committed abroad, then people should be allowed to. The UK government shouldn't condone that, and if that means supporting conscientious objectors that are abroad, or campaigning or lobbying that they not be punished for their conscientious objection, then of course I think this is part of our tradition of promoting liberal values. But as I said, this is not something I've thought about.
Yeah, Michael, maybe I'll bring you on this, because the question doesn't specifically refer to states acting, liberal democracies as states acting, but maybe I can take it in those terms, because governments are traditionally reluctant to become involved in the affairs of other sovereign states. But on this question of regimes which don't respect objections of conscience, what do you think?
Well, I mean, the question is, what are we to do about it if we do deeply disapprove of the regime's coercion of these people, or if we want to vindicate their right somehow to opt out of such coercion? Does it mean that we should extend asylum rights to people who claim such a thing? And you see, the problem with all of that is that, I mean, if you elevate this to a position of law, say, for instance, FGM as avoiding FGM as a reason why somebody could come to Ireland and say, if I live in Burkina Faso or Mali, my daughter is likely to be subject to grandmother's pressure and social pressure that I will have to subject her to FGM. That's a reason why I can come to Ireland. A lot of people, that's a deeply problematical statement, because how many people are you saying, if you're going to vindicate this right for one, vindicate it for all? If you're going to say to young African guys, say in Ethiopia, who don't want to be involved in the war in Eritrea, you can opt out of compulsory military service in Ethiopia, and the consequence is you can come to Ireland. That's a big statement. And, I mean, you can start differentiating at the airport between that person and that person. And as Fiona said, the whole process of working out who's here as an economic migrant then, and who's here really claiming that they're avoiding conscription comes into focus. So it's all I'm saying is, you can have your values and you can say, I will support people in Burkina Faso against FGM, or people in Ethiopia against conscription. But what you're going to do about it is a very different issue.
Yeah, John, you in your remarks introduced to us this notion of dignity as protecting people from their dignity being infringed as a result of acknowledging the right of conscientious objection by somebody else. Now, Ian Lee asks for Fiona and John, but I'll bring you in as well, Michael, in due course. Isn't dignitarian harm an illiberal construct? Doesn't it operate to suppress expression of moral pluralism by religious or other conscientious minorities? John?
Yeah, no, I have to respectfully disagree with Professor Ian Lee. I think there's much wisdom in his question on the issue that dignity, as I see it, is a value of equal citizenship, right? And this idea of equal citizenship, I think, is part of the liberal tradition, and definitely for the philosophers in the room, John Rawls who is perhaps the modern father of liberalism, made that central in his own account. But the wisdom I see in Professor Lee's account is that dignity as a value is both for those that conscientiously object. So in the case of the gay cakes, so the Christian objectors, and dignity is a value that serves the other side as well. So it serves those that have been refused services. So perhaps in relation to Fiona's issues, those that seek abortion services. So dignity is a value that is at both sides of the equation. And so how do we decide? Well, we can decide in several ways. One way is when it comes to claims of what we have termed as complicity claims, is that we give less weight to those kinds of complicity claims, and that would be the approach I have in relation to the gay cake case. But it may not serve in relation to all the abortion cases. Those only would.
Fiona?
Yeah, I have very little to add to what John said. To Ian's question, a former colleague of both John and I in Durham, except to say that, of course, denial of conscientious objection would largely, by persons to whom it is important, be constructed as a dignitarian harm itself. And so exactly as John said, dignity operates here in multiple and complex ways, which are challenging, of course, to reconcile, but liberal democracy is a challenging mode of co-living.
Yeah, Michael, a lot of the debate, the areas that are really contentious, I mean, just listening to the debate this afternoon, reflecting on our discussion, are around this complicity claims. I mean, the gay cake, I suppose, is one example. And I just was wondering if you might give us some thoughts in relation to that, because Ronan McRae was saying earlier that the issue really is here is how remote, if I made my note correctly, how remote the action is from the quote unquote the sin. And the more remote it is, the less weight is, he believes should be given to the claim of conscience. What are your thoughts on that?
Well, I think there's the real problem with, say, the gay cake thing is that to a liberal like myself, the affront to a baker's dignity of having to produce a particular cake with particular icing on it is, as John has just said, probably of an entirely different order to an abortion-centered dignity issue, and that applies to people seeking abortions and people seeking to opt out of the abortion process. I've a feeling, and again, because I'm against general theories, I'm cautious about saying this, but it seems to me that a lot of this is to do with the zone of autonomy and freedom about an individual, in the sense that I'll give you an example. Our employment equality legislation would allow me, if I was choosing, say, a household companion or a minder, to discriminate on gender grounds and to say, this person is going to share my life. I want a male or I want a female minder or whatever it may be. And there is a kind of a very tight zone around the individual where they are given this freedom to make discriminatory choices, which do in one sense affect others, but are tolerable on a kind of proportionality basis. Expand that to I won't have any women in my bakery, and then you see the problem is huge. So I mean, there is this kind of zone of deeply seated personal dignity and autonomy, which I think a liberal society must protect. But precisely where the boundaries of that actually should lie is very, very difficult to put down in law, and very, very difficult to establish on a priori basis. You can just describe it. It's like an elephant, when you see it, but it's very hard to define it.
There was just one question, and we have a couple of minutes left, and I don't know whether anybody has an answer to it, but it's an intriguing question, and it touches on just some of the comments earlier we've had. This is from Jerry Ambrose, when does a person or child gain conscientiousness and therefore the right to conscientiously object? Anyone? Well,
I mean, that's the example that I used earlier. I mean, at the moment, a person under the age of 18 cannot buy a lottery ticket because or enter into an onerous contract because they're protected in their childhood from doing that. Whereas we give all sorts of sexual rights below that, right to have sexual intercourse below that age and the like. I don't think that you can actually say that it's at the age of 14, 15, 16 or that, but I mean, fundamentally it is in the adolescent phase. And it's really, I think, a matter, again, on a case-by-case basis to choose for lawyers and courts and administrators to set boundaries in that zone.
Yeah, John?
Yeah, it's not a question again that I feel I have any particular expertise to answer. But I guess as a general principle, which may be not very useful, we can, if we understand conscience as the ability to define what's right and wrong, right, to have a view as to what is right and wrong, then it's possibly will vary on the age, but it's a question that I guess developmental psychologists are better placed.
In this case, there isn't a general answer then.
No, not a general answer from my.
The old catechism used to talk about the age of reason, and it curiously ascribed it to children at the age of 7, which always amused me.
Fiona?
I mean, I think as a matter of principle, children at all ages have a right to hold and form thoughts, conscience, belief, and so on. But then the question becomes at what point they can manifest or exercise that in a way that overrides objections of others, or maybe even overrides our views of what would be best for them. And as the others have said, that really is something that varies from child to child and depends on the decision, its gravity, their understanding of it, and so on. Which is not a simple answer, but understanding capacity and one's ability to make decisions that are controversial and sometimes disagreed with is simply not simple. So it really is on a case-by-case basis.
Well, listen, can I just add to that the right to freedom, conscience, and religion is recognized as a matter of international law for children as well. So. Yes, developmental psychologists will have very much to say about that, but the law as his own view, international in particular.
And the 14-year-old victim in the X case had rights and had the right to make choice about travel, abortion, to avoid suicide, and all the rest of it. Mm-hmm. So it's a very complex area, and it's not one again which you can just take out a measuring tape and say you've passed the point of moral maturity.
Just in the final moments of our discussion, have any of you ever had occasion to exercise a conscientious objection, or could you imagine in the future that it might arise? Stunned silence. John?
I can't say I've exercised conscientious objection as such, but I'm an ethical vegan, and in my college accommodation when I was a PhD student, no one was allowed to have a private fridge, right? So I had to make a case to have a fridge. To my very annoyance, the right to request a private fridge was reserved only to those that had a religious objection. So I had to make a case that ethical vegans should also be allowed to make this case. And in fact, my book is mainly about this idea that religious and non-religious conscientious objectors should be equally entitled to make their claim to exemption.
As Attorney General, I had to make those decisions, but they were mainly in respect of other people. They weren't about my own conscience, really.
All right, yeah. Well, I'm thinking, John, that your academic career is based on the incident of the fridge. I suppose there have been stranger starts to careers than that.
Many personal things have gone into my work on conscientious objection, but definitely the fridge moment was one in which my academic and personal life intersected in a meaningful way. Yeah.
All right. Well, listen, thank you all for taking part in another of the fascinating discussions we've had this afternoon. Michael, Fiona, and John. Can I also say a big thank you as well to our Irish Sign Language interpreters, to Lorraine and to Cormac, who have been busily signing away there during our discussion. We very much appreciate their contribution to the discussion this afternoon. So thank you all very much, and thank you also to all of you who put in submitted your questions. Sorry we couldn't get to them all, but I hope that we answered at least some of the questions and queries that you were prompted by what we were discussing over the last little while. So I'll hand back now to Maeve. Maeve.
Thank you very much, Bryan. And it falls to me with pleasure, but a little bit of sadness too, to close our discussion this afternoon. I'd like to thank, of course, the panellists, all of whom we asked to present their own distinctive and complex positions on an equally complex and challenging topic in less than 15 minutes, in most cases in 10 minutes, to the chairs who were asked to keep everybody on time and did so admirably. Then I'd like to thank all participants, many of whom are still here, because as I think we all know, Zoom conferences have their own challenges and complexity, and they're certainly very tiring. And 4 hours plus participation is a lot. And I'm really, really impressed that so many people stayed the pace and there were so many really, really interesting questions. So thank you everybody for being part of this. My final thank yous are, first of all, to the Royal Irish Academy, and very above all and specifically to two people there, Pauline McNamara, who is the Programme Manager for the Social Sciences and Humanities, and to Grania Lynch, who is a Senior Executive Assistant, also responsible for programmes, and both of them have been absolutely amazing in the effort, energy and imagination they've put into hosting this event. And then I'd like to thank specifically our sponsors, generous sponsors, which were on this occasion Queen's University Belfast, the Royal College of Surgeons in Ireland, Dublin City University, and the British Academy. Last words are to the academies, the Royal Irish Academies committee, I hope I get it right this time, I'm chair of it, I should, ethical, legal, philosophical, ethical, political, legal and philosophical studies committee, because it's their initiative. And the final thanks go to the working party of that committee, Chris McCudden, Noreen O'Carroll, Etna Regan and Isla Honahan, who worked tirelessly to make sure that this would happen, or to get this off the ground, and then to make sure it would happen. So thanks to everybody. And I can't say Slán Abhaile to most of you, but I can say Slán Gafol.